everyone. Welcome to another episode of GreyB Talks. I'm your host, Druva Sood. It's my absolute pleasure to bring you this very special episode. Today, we have three esteemed guests joining the show. They are all experts in SEPs, like litigation and licensing. The topic we are going to talk about is navigating IP challenges for Chinese companies in India. Before we dive in, let me introduce all our guests for today. First off, we have Muzammil Hassan. He has been on the show twice in the past. He is the Chief of Patent Licensing and Monetization at GreyB, with over 11 years of experience working with patent implementers and developers globally. Next up is Hishi. Hishi is the licensing manager at Purple Wine IP. He's an expert on SEPs. He has worked with ZT in the past, and right now he's focusing on SEP portfolio management and licensing for Purple Wine IP. Finally, we are delighted to have Vivian Wang on the show. Miss Wang is the director of licensing at Purple Wine IP Group. She has over 15 years of licensing experience, handled numerous litigation and licensing cases. One of the most renowned cases being Huawei versus ZTE FRAND litigation. Welcome to GreyB Talks, Vivian, Hishi, and Muzammil. I'm thrilled to have you on the show. And I mean, let's quickly dive in. My first question would be for Vivian. Vivian, could you tell us a little bit about yourself, your practice, and about Purple Wine IP Group?
Yeah, sure. Thanks, Druva. Thanks for the introduction. Profile is a global IP service provider, and it was founded in Shenzhen, China. And now, with over 10 offices worldwide, around 450 employees. Under our brand, we have IP agencies, law firms, IP operating companies, and also investment funds. So basically, we help our clients with all IP related matters to provide them with comprehensive, innovative IP solutions. Me now working as a global licensing director at Vivian, we assist our clients in conducting negotiations among various industries. Before joining Vivian, I've been IP in-house for almost 14 years at ZTE and in charge of the overseas litigation and licensing team. I'm glad to be here. Yeah.
Thank you. That is very interesting. Thank you for that quick introduction, Vivian. I'll quickly come to the topic for today. We are going to talk about India being an emerging jurisdiction for SEP enforcement, the kind of challenges Chinese companies, global companies are facing when it comes to India, navigating India as a jurisdiction. For this, first I will go to Muzammil, our in-house guest. Muzammil, can you tell us a little bit about what is happening in the patent world in India?
Sure, Dhruva. First of all, thank you, for inviting me again on this show. It's always great, pleasure meeting you, and Vivian, Heshi, thank you for agreeing to do this podcast. It's great to have you on the show as well. Sure, let's right dive in the India market. What's happening in India at this point in time when we talk about patents? I'd say India is really growing in the world of patents. Think of patents as like like the legal protection for inventions. For the ones who don't know a lot about patents, especially let's talk about the standard essential patents, and that's where a lot of focus has been in the past few years. Not only in India, worldwide. Let's talk about, for example, the 5G technology or probably the Wi-Fi 7 technology, right? So those these technologies are protected by the patents, and those patents are usually known as the standard essential patents. I'm really proud to say that we recently published a study where we annually checked more than 21,000 patent families against the 5G standard. So it was a 5G standard essential patent study, right? And the reason I'm proud because India is coming very close to the top five countries where these patents have been filed. So in fact, 40% of these patent families include patents which are filed in India. Now that's a very interesting stat. It wasn't if you look at the similar data in the 4G standard, in the 3G standard, or any of the other standards in the past. Right now, what does it suggest? That even though at this point in time we are not as high means in the filings in India are not as high as in the countries like China and Europe, but it's a big step forward. And why is it why we should consider it as a big step? Because It means that companies are thinking that India is important, just like any other big market. It means that the companies are trusting India's IP laws to protect their inventions. And very important, India is getting better at creating and enforcing strong IP laws. It's a long journey, I understand that, but India is on the right path.
Well, I mean, very interesting facts and figures, Muzammil. You mentioned filings have increased. How's the litigation scenario? If you talk about litigation specific to SEPs, do you have any interesting insights there?
Yeah, absolutely. I think, if there are no litigations happening, just the filings happening, then I think there is no point in filing more and more when you see that there is no return coming out. So the SCP lawsuit, seen in India is heating up as well, right? And interestingly, you might have already, I think all the viewers might have already heard about the recent Ericsson versus Lava case, but that's not the only one. In the past few years, more than 7 to 8 big cases have been filed, and most of these cases, there is another interesting fact that most of these cases are against the Chinese companies like Xiaomi and Oppo, and we understand that these companies have very big market when it comes to India. India is a big market for them, right? Even in the Ericsson versus Lava litigation case, you would see that Lava lost that case. So we can also understand the fact that the the jurisdiction or the IP courts that are being set up here are not favoring the local companies. They are law abiding. They are understanding what the law says. They are understanding what the patent says. They are understanding which company is violating the patent and which company should be awarded the damages, right? And another lawsuit against Lava is also filed, which is again a testimony that yes, India, the IP courts are doing good and we are going in the right direction. And it might also be coming from the fact that there are, if I'm not wrong, there are four IP courts that are being set up. Delhi, New Delhi IP court is there. Then we have got like Kolkata IP court, Gujarat IP court, Madras IP court, which would be solely focusing onto the IP matter. And this is a big step, going forward, that you won't have to wait, years and years just to, you know, see your IP matter going through. So these new courts are really special, and they focus on to the IP disputes, and this could make more foreign companies invest and be interested in filing more patents and litigations in the Indian market. So again, we're in the right direction, but it's a long journey.
Great, great. I mean, you mentioned a lot of SEP developers are filing in India. We are seeing litigations where global companies are being litigated in India. How are Indian companies reacting to this entire change of scenario, this improvement, and this, the focus now coming to India and with the Indian courts you mentioned?
So far, we haven't seen a lot of action from the Indian companies. That's the fact that we haven't seen a lot of Indian companies filing, patents or SCP patents. Uh, but things may change. There could be a possibility that they are planning for filing more and more patents when it comes to the newer technologies that are not yet into the market. That may be the future technologies like 6G, right? For example, if you do some research, and you'll see that a lot of articles are being published by Geo. They are doing a lot of research when it comes to 6G standards. I think they also participate on the 3GPP meetings. Overall, I'll say that there's a long way to go. India is definitely moving in the right direction when it comes to SCPs and the IP laws. A lot of companies have not yet started filing the patents or the IP towards the technical aspects. In future, we can see as Geo is stepping up, probably we can see more and more companies, Indian companies, who are trying to manufacture in India and sell, outside India, or companies who are gathering more and more or trying to convert more and more market in China and in Europe, in US. They might be willing to protect their IP, and why not India? Future could be that more and more companies could come into the picture, but right now only a few are doing it.
Okay, okay, pretty fascinating insights. According to you, why do you think India is a lucrative market right now? Why is it being preferred as a jurisdiction? Like Muzammil mentioned, there is an increase in litigation cases. There are Chinese companies who've been involved in litigations. Your thoughts on why is this change suddenly showing up?
Yeah, it's true that there are more and more patent litigations happening in India against the Chinese companies, and a lot of people are asking why this country. And I think there may be a couple of reasons. First, it's more obvious it's the market reason. We all know that India is the big focused market with a huge consumer base, and not only Chinese companies but also global companies all have their local manufacturers and operations. So I think that may be kind of like an economy question why those companies are coming to India. And from at the end of the day, from a perspective of the patent holders, it's understandable to come to this country to file litigation, looking for higher payments, and also to protect their market share. And I think, yeah, also it's interesting to see that Indian courts have shown a slight tendency to be in favor of the patent holders, at least from the cases we have seen so far, which is also very attractive. In addition to the procedural reasons, Mosme just mentioned, um, that the Indian has been setting up new courts, and it's quite helpful to streamline the original lengthy litigation procedures, and that the patent holders can get a relatively quicker decision. So I think that maybe all the reasons. I can hand over this to
Got
Vivian. Maybe she can add more comments on this topic.
Yeah, like Hirsch just mentioned, India has emerged as a huge market for those tech products and services, especially for telecommunications and electronics. So we all know that those areas are very important for SP, and SP disputes are also very hot in those areas. Also, it's just mentioned by Muzammil, some recent case law in India. I think that give a sign to us, especially for SP holders. The Indian court has more and more acknowledged the SP holders injunctive relief, especially for preliminary injunction. It's quite strong. Probably we can see Indian court has more and more to be defined as an active jurisdiction or a strong IP jurisdiction.
okay. Uh, thank you, Hershey
So,
and Vivian.
Dhruva, before you ask,
Go ahead.
the next question, I think, Hishi and Vivian made a very good point, and I want to ask this to Vivian and Ashi, and, just top of your mind, whatever comes in. From the past cases, it has been seen that India as a Indian jurisdiction or the IP courts are more patent owner friendly, right? Because most of the cases are being won by the patent owners. Now, if we see that a lot of companies have patents, but at the same time they also have a lot of market in India. For example, Xiaomi has good number of patents, but they also have market in India. Oppo has patents, but they also have a good market in India. But at the other hand, there are companies who do not have a large market presence in India, but they own a lot of patents. When we say that a particular IP code is patent owner friendly, does it give a sign that probably the companies who do not have own a lot of market in India, they could be very aggressive in these kind of markets, and it may mean that the other companies like Xiaomi, Oppo, they will be at the back foot. Does it mean that, or just want to know your comments that what does it mean, so that I understand it correctly.
Yeah, definitely. I think if like you take Xiaomi and Oppo for example, yeah, both Xiaomi and Oppo has quite promising markets there. So even if those companies has lots of patent portfolios there, when they enforce their patents in India, they of course will think about they would be attacked by the opposing party because they got a lot of exposure there. But yes, Indian become more and more active. I mean, we strong with like issue preliminary injunction. I think that could be more attractive for those we call it NPE.
Interesting. So that opens up another kind of a debate in this Indian market, that would it be opening up um, would the recent cases be opening up another market presence for the companies like who don't own products but own the patents? Would they be coming, or would India be becoming another market presence? But that's another topic for another day, Dhruva.
Absolutely. But from what
Yeah,
Vivian said, I remembered somebody telling me in one of the conferences recently that for an operating company, if you're trying to be a licensor, be prepared to be a licensee as well. So it does get targeted back. Uh, anyway, I mean, we've talked about why India is an emerging market. Vivian, based on your experience of working with uh, Chinese clients Chinese companies who are coming to India for their IP matters, what do you think are the main challenges? What are the key issues these companies are facing in India at the moment?
yeah. Nowadays, I think the most big challenge for most Chinese companies is that we're not so familiar with the Indian legal system and the IP law. This feeling kind of remind me the feel of 10 years ago when I was in VTE, when we faced litigation in US and European countries. It's kind of the similar feel that time. But with these years, we see a lot of case law established in US and European countries. We also did lots of research to monitoring and following those cases. For India, I think it's just like what we did 10 years ago. It's familiar with the whole IP picture in India, and we don't know how things work. We don't know the court's attitude towards the SP holders and implementers. Although, as Muzammil just mentioned, there's some high-end case law in Indian courts, but it still has very limited information for public available. It's hard to track those case detail.
Hmm, got it, got
And
it.
it reminds me of one conversation I've had at IPBC. Uh, and so there was this one panel, at IPBC Europe, and the panel was related to the SEP litigation. And somebody asked that, would you prefer going to the Indian market now? To, I think it was I think the licensing head of Nokia or one of the top telecom companies. And the answer came in, which was very surprising, but it was, again, very similar to what Vivian said. The answer came in that we would prefer going to the Brazilian market than the Indian market, even though the Indian market is very. It seems that is a big market, but at this point in time, we don't know a lot about the IP considerations over there. We don't know how the IP law works, and there is another problem that was highlighted in that particular discussion, that in India it usually takes a lot of time, sometimes 5-7 years to uh, get a case move on to the next stage or get a verdict out of a particular case. So they wouldn't want to wait these many years. But
Hmm,
having said that, now that a new IP focused courts are being set up, there are four in the picture right now. So this may change. But again, as Vivian said, unless India starts giving more and more information about what's happening at the back end of when a particular case is being uh, dealt with, or how the judge is thinking, how the evaluation is happening, how the law firms are talking, how the arguments are being made, how the patents are being uh, probably argued about. So I think it will be really difficult to gather that trust from the foreign companies to invest, because one litigation costs hell lot of money, right? So it's also an investment. So if you want people to invest in a litigation in India, I think it's a high time that we should start talking a lot more than what we are doing right now.
got it. I
Yeah,
mean,
yeah, sorry. Yeah, that's why I think that's why we need what GreyB now provides, because those data are important for us, for like for Chinese companies to make informed decisions. We need those data to have a clearer, more clear SP landscape in India.
well, I thank you for highlighting those challenges, Muzammil and Vivian. I hope uh, you know, there is a change, there is improvement, and I hope these things also will improve in the coming years as the system grows. But coming to my next question, which is again, I'll come back to Vivian for this one. Vivian, which are the major industries according to you that are more focused and facing these IP challenges in India, and how is Purple Wine helping these companies overcome some of these challenges?
Yeah, definitely. I still think the telecommunication and electronics could be a major concern. And we all know historically these sectors are hotspot for SP disputes. But with the advancement of IoT technology, we also noticed that this SP disputes has expanded into some new areas such as vehicle, medical device, smart meter, also post machine companies which need connectivity. It undoubtedly this will make IoT a new background for both SP licensing and litigation. So referring to what can Purple do for these companies, Purple has an extensive experience in handling these international disputes with numerous clients. Yeah, we have a strong network of legal resources, so we can get involved in the case at very early stage to give our clients very timely overall advice. Or when facing the licensing litigation, we can help our clients to manage the entire process smoothly, and we can help them to develop the comprehensive IP strategy aligned with their business goal. And also, we have a sophisticated set of mechanism to help clients manage their legal expenses effectively.
Thank you for sharing those information about Purple Wine and how they are assisting the clients overcome these challenges. Thank you, Vivian. Uh, Hishi, I'll come to you for this question. Based on your experience, how are these challenges? We've talked about some challenges that are in India. How do you feel these are different from the challenges that global companies might face in China, in Europe, in US, or other primary jurisdictions? How are these challenges different from those?
Yeah, compared with those well-established jurisdictions like the U.S., like Europe, and even China, I think the biggest difference about India right now is still the difficulty to obtain information for Chinese companies, and not only the litigation information but also the patent data. Let's say, for example, over the past years, retrieving the patent data from the India patent office can be quite challenging sometimes, especially for those companies with limited resources. And but we were happy to see that the Indian Patent Office has made a lot of progress in digitalizing the data, making it more available for the public. Yeah, yeah, maybe like we were talking about Provine, what we have done is to help our clients to connect with the local resources and to um, respond to the challenges more effectively.
Okay, thank you,
So,
thank you for
there's an
yes,
interesting
Muzammil, go ahead.
stat that's coming to my mind. I'm sorry to cut you again, Dhruva, but this interestingly. So when we talk to our clients, so we have a lot of clients, which are like US based clients, European based clients, Chinese based clients as well, right? And so when we talk to them right now, from the licensing or the litigation front, that they own patents, now they're thinking of, for example, to go into a litigation or to go into a licensing, right? I can I can very easily say that on an average, 20% of those clients often talk to us about, in one way or the other, about the Indian market. They talk to us whether they should be filing more in India, how GreyB could help them, whether they should be, if they want to go into litigation in India, what's the procedure, how they should be doing it, how GreyB could assist them and all that stuff. Right? If I look back, 5 years ago, it was zero. So now from zero to 20%, it's again a positive change that I could see from the discussions that I have with my clients. So if I ask you, Vivian and Heshi, either of you can answer that. So when you talk to your clients, you have like a lot of clients who are based out of China. you don't have to put it in the percentage of the numbers, but how often do you think the discussion about India, happens when you talk to your clients about the licensing or the litigation stuff? Is it like once in a while, two or three, or five out of 10? What would you say?
Yeah,
Yeah,
it's really hard to give you a specific number about the percentage, how often we notice and talking about the Indian jurisdiction. Yeah, it's a fact. I just recall we more and more to give Indian market a notice, and we discuss it because of some specific event. Like we notice some lawsuits there, and we asked by our clients uh, to provide them some overall like law firm choices or like some appeal for case advice. Also mentioned when conducting licensing, notice that some licensor, I mean some patent holders, they are thinking about to enforce their patents in India. So that time maybe the licensee and the implementers reactively to notice and to have wanna have some knowledge about the Indian IP landscape.
And that makes sense too, even from the reactive perspective, or from the proactive perspective. But what is good is that in either of the cases, people have started talking or understanding more about the Indian market. And that means that if people are talking more about Indian market, they want to know more about Indian market. So once you start reading about a particular market, it's likely that people will start investing in that market too in the long run. So yeah.
Maybe yeah, maybe nowadays for most Chinese companies they are just reactive and they are respond to those different kinds of action from the other party. But I believe later in the future, Chinese companies could active more proactively to play some role in before Indian court. Yeah.
Interesting, interesting. Very good to know.
Well,
Over to you,
thank you,
Dhruva, again.
Muzammil.
Yeah.
Thank you for asking that excellent question, and Vivian, thank you for adding those comments. Very interesting. I think on similar lines, I want to ask my next question, and I'll come to you, Vivian, for this one. I want to understand about the most important considerations Chinese companies or your clients have when they are starting to prepare for a licensing negotiation, and then what are the most important things that they are considering, and do you think is there a way that GreyB can add some value to that overall process?
Yeah, sure. Just like I mentioned, with the advancement of IoT technology, lots of IoT related companies would involve in the licensing negotiation. So first of all, I think it's important for them to have the awareness that licensing negotiation is just a normal and regular business activity. So don't be afraid. Take it seriously and quickly grasp this international norm and effective to deal with that. We all know that licensing negotiation would involve technology, law, and business discussion, and ultimately to serve a corporate's business goal. We should bear in mind there's never one size fits all negotiation strategy. So players must have a deep understanding about the industry and also the unique characteristic of this company, then tailor a negotiation plan for that company. And like I said, ultimately, we need to serve the corporate's current business goal.
Mm,
So as for my side as a licensing director, I think it's worth to work harder for negotiation side to avoid the litigation, so to get things resolved amicably. Most important,
mm.
economically.
Great, great.
Very interestingly put, that particular comment, Vivian, that um, it's a normal business activity. It's a very interesting way of putting the thought that
Mm,
licensing is a normal business activity, and it's very true, because I have seen two parties getting into a licensing agreement in a very positive mindset. they're not afraid of each other. It's just, one party owns the patents and the other party is okay to pay because the other party knows that somebody has done research and they have put in a lot of money, and it's okay to pay as a licensing fee. I think the message goes to all the Indian companies as well. When the IP laws are going stronger and stronger in India, and we see foreign companies investing in IP in India, then it's likely that you will receive a lot of letters. Receiving a letter about starting a licensing uh, you know conversation does not mean that it's a threat letter. It
Yeah.
should be considered that it's a business opportunity, it's a business transaction that is going to happen. You are using a technology, you're earning out of your product, but the technology is owned by some other company. It's a very usual practice. So yeah, means I think I really like the way you put it, Vivian, so thought I should share it.
Muzammil, I would like to ask you, and if you can add a few comments about uh, what are the ways your team, GreyB as such, is helping with these companies prepare around licensing. Can you share some thoughts on that?
Yeah, absolutely, absolutely. I think that's what we do. That's the bread and butter for us. So as Vivian was saying, so she helps in the licensing negotiations, mostly from the front end there. And now the negotiations needs a lot of backend support, and that's where GreyB comes in. The backend is understanding, for example, if two parties are getting into a licensing conversation, right? Now understanding what those conversations are about, what the portfolio is in the picture. If a particular portfolio is in the picture, that what value that portfolio holds. Are there any patterns that could be um, you know that could be interesting from a licensor point of view, or that could be interesting from the licensee point of view, because we could as a technical support, we could represent either of the parties. Sometimes we are representing licensors, sometimes we are also representing licensees. For example, if we talk about from the licensing's perspective, then it's very important to understand what the portfolio holds for you. Means, are you going to get any benefit if you're going to take the license? Are you already using that technology? Is the portfolio relevant to your products or not? Is the portfolio covering the jurisdiction that you have a lot of market in, right? Are there any loopholes that you can exploit while going into the negotiation discussions? So when we say loopholes that could be exploited, again in a very positive sense, that somebody's asking $10 million, but you want, of course, you would want to negotiate and take it up to $5 million or lesser probably. So how you can do that? So we try to identify those loopholes. Are the patents have good strength when it comes to are those patents going to hold up if taken to the litigation, for example? So how strong those patents are. So these are some technical support that could be needed when you're going into the licensing negotiations, either from either of the parties, and that's what we do at Grade.
Okay, thank you, Muzammil, and thank you, Vivian, for sharing your thoughts on this. We are in 2024. The buzzword for the year is AI. When we are talking about licensing negotiations, FRAND rates being set up, in all of this scenario, what do you think is going to be the role of AI, and how will AI affect this business? As Vivian mentioned, I'll go to Vivian first for this. Vivian, your thoughts on this?
Yeah, interesting. Yeah, we talk a lot about AI, even in legal field, specifically to licensing negotiations. I seldom to think about AI to totally replace, I mean, my role. But like I said, when we talking about SEP, of course, we know that there's a friend framework, friend principle need to comply with. So when we see friend, I see we can see it from two main aspects. One is the behaviors of both parties. I mean, licensor and licensees' behavior during the negotiation process. The second aspect is the royalty part. the offer and counter offer. So when we refer to the first aspect, behavior, and like I said, there's no one size fits all negotiation strategy, and we also don't see the detailed regulation to regulate all possible scenarios for negotiation. So it's really hard for AI to do this part of work, I think. For the second aspect regarding the FRAND rate, we all know FRAND rate. We have two main methodology to calculate the FRAND rate. One is top down, another is the comparable licensing rate. So for top down, because it's related to the essentiality check, so I do think AI can have a significant assistance of this point to do the patent essentiality check for us. But for another methodology, the comparable licensing rate, because most license agreements have the strict confidentiality clause. I don't think it's possible to feed the AI with those data, so it's hard. But generally speaking, I think the crucial part for negotiations to design, develop develop a comprehensive IP strategy, which is dynamic according to the negotiation process. I think that's a part AI can do, at least at this moment, I think.
Got it. Thank you. Thank you for sharing. Very interesting. So AI can help in certain aspects, maybe not all. Muzammil, your thoughts on AI and its role in licensing and front rates and all of this?
Well, if you're asking that should we start using AI in our in the licensing negotiations or setting the FRAND rates, I'd say absolutely why not, means we should be, but it's very important to understand where to use and when to use the AI, right? AI is just like any other technology that at the start you would feel that it will do everything, but then slowly you start realizing, okay, so there is some human touch needed to to use it the way it should be used, and to use it so that it can actually give you the value, right? So it's a funny saying that you want AI to do the job, but you don't want AI to take your job. So uh, So funnily put it in this way, but yeah, as Vivian was mentioning that there are behavioral aspects as well. Probably essentiality check, you would say that at this point in time, even if AI is not at par, probably in next 5 years, we'd see that AI would start understanding more context of the patterns and probably start comparing the patterns in a better way. So, but essentiality is not the only part of a negotiation cycle. It contains a lot of other aspects. For example, understanding the behavior of the other party. How are they going to come aggressive? Are they going to how they're going to react to our negotiations? How they're going to uh, assisting? How well are they assisting in the negotiation cycle? For example, right? So a lot of factors are there, which at this point in time probably are very difficult to understand just by analyzing the data. But then at the same time, there are a lot of factors which where AI can play some role. So I'd put it in this way that we should be definitely working towards taking AI to that level where we can leverage it to do better licensing deals, to do those quicker and smooth licensing deals. But at the end of the day, it's human who is going to be the judge and who's going to evaluate whether it is going to work out or not.
So I think somewhere in line with what Vivian also mentioned, but I would want to hear Hershey also. Hershey, what are your thoughts on the use of AI in all of this?
Yeah, I think I can add some comments on the essentiality check part when it comes to SEP because I have been dealing with a lot. Yeah, so in terms of like SEP essentiality check, I can already see that AI has been leveraged into some database or tools to do that work, but I can pinpoint some limitations of using AI. First, I think from my personal experiences, I think AI right now can only works in terms of essentiality check can only works for those English original patent documents, which means the US patent, the European patent, Australian patent, and so on. The accuracy is not confirmed for those machine translated like Chinese patents, Korean patents. So how do you rely on those data is a problem. And more importantly, I think the results of AI essentiality check can be systematically biased sometimes. By that I mean, if a claim that has more languages or terms that we can find the exact same thing from the standard sections, then this claim will look more essential to the AI compared with another claim that has maybe broader claim languages, even though the second one can be more fundamental or essential to the standard. So this bias is something that we should be really careful. And also, AI can sometimes only cannot differentiate the partial mappable claims to with the fully mappable claims. So those with all those limitations, I fully agree that AI at this moment can only be used as a tool, uh, and the accuracy we can only get the accuracy with the combination of this tool and the human expertise, like for example the manual claim charting and the essentiality check. Yeah.
Okay, great, great. Thank you, everyone. I think some very interesting points. Of course, I think the general trend seems to be there are certain aspects that we can rely on, but then again, there are a lot of aspects of licensing where I think there is more time for AI to take over some of those tasks. Uh, Cool. Thank you everyone for sharing your thoughts. As we move towards wrapping up today's episode, I have a final question for all three of you. We will again start with Vivian, but the question is that uh, based on your experience, you're seeing the dynamics of the markets move. Based on your experience, what are the future trends you see in the SEP landscape when it comes to India, China, for all the foreign companies that are looking at both of these jurisdictions? Vivian, we'll come to you first for your thoughts.
Yeah, yeah, sure. Yeah. I think both China and Indian are willing to get more involved in shaping an SP landscape. It would be expected that both countries will continue to strengthen their enforcement mechanism towards SP-related disputes that would provide more clarity and predictability for those stakeholders. And also with emergent technology in both countries, I think China and India are likely to get more involved in in creating new standards. So therefore, we can see an increased number for those domestic countries in China and India to declare and assert their SPs. So they can have a greater influence on the global SP ecosystem.
Great, great. Muzammil, do you want to add some thoughts on this?
Yeah, I agree with Vivian. I think it's, I'll just say that it's on the rise, for both the countries. And it's been on the rise for the past 5 years. We've seen that. We've seen many active, filings from the foreign companies in India, Indian companies involved in filing patents. We've seen all that, right? We've also seen, as I talked when we started this podcast, that there are multiple litigations that has happened in India, and we've also already seen. You will find if you do some research, you'll find that China has already been um, you know among the top jurisdictions focus for many of the patent owners. So just like any other IP savvy jurisdiction, China is just another focus for the patent owning companies. Other than that, I think a very interesting stat that's coming out is that the Chinese companies have started filing a lot more outside China as well. For example, be it like Xiaomi, be it like Oppo, ByteDance, Alibaba, Huawei. See that those companies are filing very heavily outside China as well, and they are also aggressively licensing, reaching out to the companies. Some of those have been reaching out to the companies, and some of those have been on the other side of the licensing agreements as well. Uh, but again, in my opinion, both the countries are going to see a rise in the patent disputes, in the patent agreements in the coming in this decade. Probably one interesting thing that we should all watch out for, that how Indian companies are going to take it. Are they going to file more patents? Are they going to start filing in India and then to the other countries? How they take it? How would they take the probably the licensing agreement that are going to happen between the Indian companies and the foreign companies? So that would be interesting to watch out for. But yeah, it will be on the rise.
Great, great. Thank you, Muzammil. And finally, Hershey, how about you? Any thoughts on the future trends?
Yeah, it goes without saying that India is definitely a heavy focus for almost all the large patent holders for their patent portfolios. As Masmei just mentioned, almost like 40% of the 5G SEPs have Indian national filing. And if you look at the data, many of the patent applications are still pending. So with more time, we can definitely see a huge increase of the patent data when more and more patents become public and granted. And also with all those advantages of like improved legal procedures and the attitude of the Indian local courts, I think litigation can also be on the rise. So yeah,
Hmm.
we'll see.
Great, great. Thank you so much for sharing your thoughts on this. Well, on today we've talked about a lot of things. India is an emerging market. It is being preferred as a jurisdiction of interest for licensing and litigations. There are some key challenges. There's more information needed about the case laws, the overall procedures in India at the moment. We talked about how these challenges are different for from more fixed jurisdictions like China, Europe, or US. We talked about AI being you know being able to cover some portions but not all. AI should do the job, not take the job. Licensing is a business. Some very interesting insights came out of today's discussion. Thank you, for sharing all of this. Thank you, Vivian, Hishi, and Muzammil for being on the show. The things you've shared, I'm sure our viewers will find it very interesting. It has been an absolute pleasure to talk to you all. Uh, and I look forward to hosting you all again on another episode of GreyB Talks very soon. Thank you once again. And to all our viewers, bye bye.
Thank
Thank
you.
you.
Thank you. Bye bye.